There he is. Okay. You're up, Mr. Johnson.
May it please the court. My name is Charles Johnson, and I represent Helen Schell in her capacity individually and also as trustee. I'd like to reserve 5 minutes of my argument, Judge Northcutt. First, I'd like to make two initial observations. My initial observation is it would be difficult to overstate the importance of due process in American jurisprudence. It is simply a bedrock portion of our law, and it is so important that it is incorporated specifically in the 14th Amendment to the United States Constitution and Article 1, Section 9 of the Florida Constitution. Having said that, some concepts of due process are complex and nuanced. This is not one of those concepts. Today, we are here to deal with a very narrow and very straightforward issue before you. And in that regard, I don't want to be melodramatic. I read the instructions on the oral argument in the last couple of days. I don't want to hold anything up, but if I were to do that, what I would be holding in my hand is 23 sheets of paper, specifically the complaint and the motion for injunction in this case, because the review by this court is confined to those 23 pieces of paper. And the question before you is whether those 23 pieces of paper demonstrate an immediate threat of irreparable injury that forecloses the opportunity to give notice. In the vernacular of this court, in the Hunter case, the movant seeking an injunction without notice must show, A, how and why giving notice would accelerate or precipitate injury, or that the time required to notice the hearing would actually permit the threatened harm to occur. And in this case, let's take a look at those 23 pages. Because
can I interrupt you for 1 second? What is the standard of review in a case like this when you have a trial court acting in its capacity as a probate court?
I believe your Lewis opinion is instructive in that regard and says that the review on appeal is limited to the sufficiency of the complaint and order, and thus is a de novo, is as a matter of law, de novo, Your Honor.
So you don't assert that there's an abuse of discretion standard involved here?
Absolutely not, Your Honor. That is a key disagreement between me and the appellee. The appellee cites two cases, specifically the case of Landau and Gainesville Women's Care with respect to the standard of review. And both of those cases were injunctions with notice as opposed to without notice. And then
the follow-up question is, your client was given the opportunity for a return hearing, correct? After the injunction ex parte was entered, there was provision that your client could have had a return hearing, but chose to file the notice of appeal instead. I understand you're not required to have that return hearing, but that would have been an opportunity for the due process that you're arguing for.
As I understand the law, which is State versus Beeler, it is the option of the party against whom an injunction is entered without notice. I don't want to split hairs. There was never a hearing set. My client did not. It's not as if my client did not attend a hearing that was scheduled. I concede, Your Honor, I think your statement is accurate, that one of the options was for her to have pursued a motion to dissolve.
Okay, proceed.
Moving forward with an analysis of the complaint, what the complaint does say is in paragraph 13, it is unknown what Helen has done. And in paragraph 26, it says the appellee will have an inadequate remedy if Helen distributes or spends. Those are not instances of an immediate threat of irreparable injury. In paragraph 30, the complaint says the money, quote, could, quote, disappear. Again, not an immediate threat. And notice was not given to my client because the, quote, potential, quote, harm was too great in paragraph 31 of the complaint. There is simply
Mr. Johnson, do you agree that a party does not wait till the actual misconduct takes place? For example, your opponent does not have to wait till your client purportedly steals money or improperly transfers money. they have to make a showing that it is likely to occur or a strong possibility that's going to occur, doesn't it?
I believe the vernacular of the case law is that there is an immediate threat as opposed to speculation or conjecture. And I don't want to take, well, I do want to take issue because I don't think the fact that it might happen or even that it's likely to happen, it has to be an immediate threat. It's about to happen. It's exigent. And the court has to take action to prevent.
The reason I raised the question is, and I think you just answered it, it is sufficient if it is an immediate threat. The way you worded it earlier, and I think in your brief is, well, nothing was taken. They're speculating that it could happen. Well, it may be speculative, but to the extent that there is an allegation of immediate threat of irreparable injury, it is the threat that is sufficient. It doesn't have to be actual ongoing conduct, correct?
I believe it could be either in the vernacular.
Okay. That's, I just want to make sure we're on the same page as to what the law requires.
Yes, Your Honor, I believe we are on the same page.
I have a follow-up question also. Your client amended 2 different trusts. Is that true or false?
My client did not, the decedent did.
Okay. Well,
but there are 2 trusts.
Well, let's just put it this way. Your client was in custody, so to speak, of the decedent while these amendments were made. And my real question is, the amendments were not notarized. Is that correct? And are they required to be notarized?
They were not notarized at the time. They were notarized subsequently. And then the question is, under the trust code, whether substantial compliance would be sufficient for the trust amendments to be effective. And that would be a decision for the trial court. But that leads me, if it's okay, Judge Valenti, for me to transition into one of the points that I wanted to make today, because I've been telling you what this appeal is about. And I also want to make sure that I tell you what it's not about, because what it's not about is the health of Francis Schilling, the decedent. It's not about the estate planning of Francis Schilling. It's not about the allegations of undue influence against my client, because the key to an injunction without notice, it's a temporal or a timing component. The question is, at the time the injunction is entered on July 20th, 2021, was there that immediate threat? And I want to circle around to a sequence of timing that was not highlighted in my brief, but I think is instructive for this court. Frank Schilling, or Francis or Frank Schilling, died on December 30th of the year 2020. Immediate threat at that time, which is the reason the underlying lawsuit was not filed in the trial court for 6 months. So from December 30th, 2020, when Francis Schilling passed and my client became trustee, exactly nothing was done by Paul Schilling until June 26th. And I want to follow that forward because on June 26th, the complaint and the motion for injunction were both filed. My client was served on July 8th, which would be 12 days later. She was served only with the complaint and not with the motion for injunction.
Well, that's not in dispute, is it? That's not in dispute. That was intentional. That's why it's an injunction without notice. Otherwise, we wouldn't be here today, right?
I agree. I think it's important that the time period from the passing of the decedent until June 20th, if this had been filed on January 1st, the day after he passed because of some concern, but 6 months passed and there's not any explanation.
Okay, but there was no evidence on that point one way or the other, was there?
In
other words, when your client declined to have the hearing and chose to file an appeal, your arguments are speculation. We don't know why it took 6 months. That's an assumption we can't make.
I don't think it's an assumption you can make, but some of the case law does look and say, when you're talking about how quickly if somebody is concerned about her acting as trustee, if the notion of her being trustee standing alone is concerning, then you would expect this lawsuit to have been filed within a few days.
Your argument is it's a de novo standard, not an abuse of discretion. So if it's a de novo standard, time is not irrelevant. If it's abuse of discretion, that would go more towards an abuse of discretion. And your opponent's in that camp.
Yes, Your Honor.
All right, thank you.
I want to move on briefly to the issue regarding the bond before, but so the issue does not get lost. The injunction was entered on August 4th of the year 2020, which means my client's been enjoined for approximately 6 months already. No bond was even required until October 3rd. So my client was stripped of her trusteeship, stripped of possession of all of the trust assets, and they were transferred to a stranger not appointed by her father. All of that was done without a bond, and in fact, the trustee administered the trust for at least 2 months without a bond.
Let me ask you one question, Mr. Johnson, as far as the bond issue. If we were to affirm on your primary issue and conclude that the injunction was appropriately entered, is the bond issue moot?
I think so, but I don't want to concede that. I occasionally read a appellate opinion which says somebody conceded something in oral argument. So I don't want to say I concede, but I can't make an argument at the moment.
Right.
I don't want to say something that I don't believe in, Judge Silverman.
Okay.
So let me ask you this. You said the trustee administered for how many months without a bond being posted?
At least 2.
Okay, the bonds, which suggests the bond's been posted. Now, is this issue now moot?
I believe it has now been posted, but I'm always reluctant to say something that appears outside the record. But since you asked the question.
Well, mootness necessarily goes outside the record, right? Because it involves issues that have occurred since the order.
I believe that it has been. But I think I don't think a copy was sent to me. I recall looking at the clerk's website, and Mr. Scuderi and I exchanged some emails about the nature of the bond. So I would prefer that he address that.
I get that.
I believe that it has been. So I don't want to leave it open unnecessarily. I touched on it earlier, but one of the fundamental disagreements between the appellant and the appellee with respect to the law is not only on the standard of review that we've discussed already, but otherwise with respect to the discretion of the trial court. It is our position of the appellant, that cases involving notice simply are not applicable, because when you've given notice, obviously both sides have been given the opportunity to put forward evidence. Now it is an abuse of discretion. It is a weighing of evidence, determination of credibility, none of which occurred here. So all of the cases cited by the appellee in his brief that are with respect to having notice are not persuasive here. I'm going to conclude and simply say that the general rule in the overwhelming majority of cases, because there is not an exigency present, is that notice must be given as a result of due process. In this case, there is simply not the factual predicate for the trial court to have entered an injunction without notice. This case must be reversed.
John Scuderi, Goldman, Falkowski, and Stone. I represent Paul Schilling as the appellee in this case. It's an awful set of facts here. And as you pointed out, it's the only set of facts we have. We have substantial wealth. We have a trustee that, because of deficiencies in the face of the document, is not validly appointed the trustee of this trust. So you therefore have this substantial wealth in the hands of a stranger to this trust. There is no substantial compliance, as counsel references, because the statute he references in his brief applies to revocable trust. The charitable trust is not a revocable trust, it's an irrevocable trust. So it's strict, literal, you have to literally follow the confines of the document, which require—
There are 2 exceptions to irrevocable trust being amended. Is that correct?
I didn't hear the first part.
There's two exceptions to an irrevocable trust being amended. And
Well,
did any of those exceptions apply in this instance?
No. He did not reserve to himself the ability. Well, it depends what we're talking about. If we're talking about the trust, amending the trustee provisions, he could not do that because he did not reserve the right to do that within the document. He did reserve to himself the right to change the charitable trust beneficiaries. But in order to do it, he had to comply with the procedures he laid down. That writing changing the beneficiaries be notarized, and it was deficient in that regard.
He says they were notarized after the fact, a few months later. Does that cure the deficiency?
No, because it's the implication is it's the decedent's, it's the settlor's signature that's being notarized. If the witness signatures needed to be notarized, then the trust would say that. That would be unusual. So the implication is it's the settlor, the person that's
All
making
right.
the change.
And the other follow-up is the standard review. What do we have here? What is the standard review, and why is your position more correct than his?
Well, if you look at Wise v. Schmidt, that was an ex parte injunction entered.
The third DCA case.
Right. And their review of that was clear abuse of discretion. And you've got the Landau case, which again was another trust case. I don't believe that one was ex parte, but again, they said in there, freezing trust assets is not a due process violation. And they looked at that as a clear abuse of discretion standard.
They also seem to run with the concept of inherent jurisdiction, which would override the temporary injunction statute 1.600.
Absolutely.
So in other words, it's a little bit confusing, but apparently there was no duty to comply with the injunction statute, just the probate or the trust sections. But if you comply with both, then you make a double argument. You cover your belts and suspenders kind of thing.
Correct. The court had an inherent authority to do this. Not only those common law cases that we cited, a ton of them that go way back, but then since then you've had the trust code, which it really leaves it wide open as to what the court can do, including preventing harm before it happens. So when you read all of that in conjunction, whether we're going down two roads, one of which is 1.610, and the other one would be the common law and the trust code, or whether it's all one road, it doesn't really matter.
Your client seems to cite a lot of cases about inherent jurisdiction not applying in a situation where you're seeking money damages, and he doesn't cite any probate cases that seem to be on point in his favor. Do you have any comment on that?
You're saying that my opponent doesn't, or I don't?
No, he doesn't. He cites money damage type cases,
right,
that arguably you can't restrain someone from disposing of their own money. But here we're talking about a trust and it's third party money. And I didn't see any case law that broke his way on that issue.
And that's true. He stays away from the estate and trust cases and the inherent jurisdiction cases, and stays in strictly with those 1.610 cases that really don't apply here. When even if you're going to look at 1.610, it's applied differently, because here in these types of cases, you have that strong public interest in marshaling these assets and preserving them for the decedent. So, that strong public interest is not going to be present in the types of cases that he cites to. And of course, he cites to Kunze. That's a trust case, but that's not an injunction case. It's not a case where the court was invoking its inherent jurisdiction to preserve and protect trust assets.
Well, although my final question, I'll think I'll leave you alone, is Chapter 736.1001 sub 2 seems to give the probate court substantial discretion to remedy a breach of a trust that has occurred. This is a quote, has occurred or may occur. So you
Correct.
don't have to even have a breach. It's an anticipatory based upon facts of record. whether those facts of record were allowed to stand for 6 months or 6 days or 6 minutes, I don't see that as a test, but there has to be something in the record to support the trial court's decision to issue a new order changing the trustee.
Right, and you've got that here. You've got when you look at the document that she's not a validly appointed trustee of the charitable trust, and you've got out of state beneficiaries here for again not notarized, so not a proper change to the trust. So
Is there anything to be made of the fact that some of the charities were in favor of the injunction, so to speak, and some were opposed? Does that carry any weight?
This order has very limited impact on anybody. It's preserving
the status quo preservation.
Exactly. And it's in their interest. It's really in everybody's interest for these assets to be secured and safe. And then at some point, the court will rule which versions of the trust are correct. And then the ultimate beneficiaries will know that this money has been safe and it's safeguarded. And as you pointed out, at any time, Helen, Schilling can come back and offer the court a different set of facts and try to change his mind. But she hasn't done that. So yes, it's in their interest.
Did you want to talk about the bond issue, the delay in posting the bond, or the limitation of the bond to 100,000?
I mean, hopefully, as you mentioned, it's moot because the court clearly had discretion to enter this injunction. The rule gives the judge discretion to do that. I mean, if the court doesn't set a time, then it's 5 days. Here, he picked a time. He said 60 days, but there's no harm to anybody. And the bond, again, it's not in the record, but the bond is posted, and I believe we filed something indicating that it had been posted. And Mr. Johnson and I had some discussions, prior to it being posted. So we complied with the order. There's no legal authority out there that says it's wrong for the judge to do that. He didn't cite any. I know the other side cited a case where they said it was disfavored, but that was prior to the 2020 rule change. So clearly the rule leaves it open for the court to delay the posting of a bond. I mean, there's no harm.
One last question.
Mr. Scuderi, apart from the fact that it may be moot, and we'll determine that as we get through the case, but was there any information that the record reflects as to how the judge came up with 60 days as opposed to 5 days or as opposed to 365 days?
I don't know. It's not reflected. I mean, I think maybe this had something to do with it. Maybe it didn't. He really gave my client the choice on how to proceed. He thought, look, I've got authority under the common law and the trust code to do this. If I also have authority under Rule 1.610 to do this, but if you move under the rule requires you to post a bond, that sort of thing. So I don't know if that had something to do with it or not.
Well, it just does seem puzzling that the court would order the posting of a bond to basically 2 months after the injunction is entered, which in my mind creates some risk, but that may end up being neither here nor there.
In some cases, that absolutely could be a risk. But remember, a bond is really not appropriate here because this is, again, a status quo order. This is a potential beneficiary or a potential trustee coming forward saying, look, Your Honor, just exercise your inherent jurisdiction and protect these assets for the beneficiaries. So there's really no occasion as to why a beneficiary would have to post a bond in that situation. But the court did it because he felt he had to if we were going to pursue the 1.610 remedy. So in this situation, there really is no risk of harm because, again, it's just a status quo order, freezing trust assets and putting them in safe hands.
So here's my last question, I promise. If your opponent is correct and the standard review is de novo and not a clear abuse of discretion, does that change the outcome of this appeal?
Absolutely not.
And why not?
Because the facts here are awful. I mean, this person looks like an undue influencer. You know, her parents have been planning since going back to at least 2012 that their daughter would not accept their desire to leave their money to charity. So you see that they put $1 million gift in there for each kid with the hope that that would discourage the daughter from challenging the validity of the document. And then you see in 2020, what ended up being the last conversation Paul had with his mother is telling him, watch out for Helen. Don't let her steal the estate. And then as the mother dies and as the father rapidly goes downhill, gets to a point where he's dying, he's on comfort care, supposed to be on hospice, whether he was or not, we'll find out. And suddenly changes are being made when he was in no condition to arrange, approve, or maybe not even understand what those changes were. And they favor the person who was isolating him and had control over him. So, you know, when you look at these facts, the deficiencies in the documents themselves, that she was not a trustee, and the way that these documents came about, absolutely. I mean, this passes any standard. I mean, this is what a court is supposed to do.
Well, there's no dispute. Is there any dispute that Mr. Schilling was 89 years old, needed 24-hour care, had Parkinson's, dementia, a lung infection, and other ailments? Was that disputed by anyone?
Well, they didn't file anything contesting any of that. So you're
So on
stuck.
the face of
And
the
they didn't set a return hearing to
Correct.
challenge.
They had an opportunity to set a return hearing and could still do that, even if you affirm this order.
Okay, thank you.
Thank you.
Jonathan?
May I proceed, Judge Northcott?
Yes. I assume Mr. Scuderi was done.
I want to try to address some of the topics that were brought up in that broad discussion. First, the question was the case law. Let's talk about the case law, because I specifically went through all 13 of the cases that were cited by the appellee, which was, as I heard them referred to, a ton of them a few moments ago. The simple fact is there are only 2 of those 13 that address an injunction without notice. The Wise opinion, which contains no facts whatsoever, and the Maldonado opinion, which supports the position of my client, because in Maldonado, the party seeking the injunction came to the court and said that the alleged wrongdoer, quote, had already transferred considerable assets owned by the decedent to herself, such the theft was already occurring and ongoing, which is distinct and different from here. There are simply 0 of the cases, the 13 cases that are cited in the answer brief, that will support an injunction without notice here. I believe it was Judge Valanci brought up section 736.1012 as to the court's ability to prevent harm in the future. And it is true, certainly true, that the statute says that. It is equally true that the statute, which is a matter of right, does not specify the procedure for doing so. And the idea that a court can ignore due process and ignore 1.610 in order to enter an injunction, ignoring the dictates of our constitutional due process, is simply incorrect. There is no legal support for that notion. I briefed it extensively in the initial brief, and there was exactly no substantive response in the reply. The third issue that was raised related to the trusteeship, and the trust, by the way, it's Roman numeral 5, subsection D, does make reference to the settlor having the initial power to name a successor trustee. But again, we're going down a rabbit hole there that we shouldn't be going down. And that's where I probably should have foreshadowed this more in my initial argument. This case is not, repeat, is not about what my client is alleged to have done wrong. This court has been unmistakably clear in the Lewis versus Sunbelt opinion. You are not to address the merits of the underlying injunction. The issue, the sole issue before this court, is whether there is an immediate threat of irreparable harm that forecloses the possibility of notice. And the answer to that question is absolutely not. There is simply nothing in the 23 pages that this court is authorized to review which would justify entering an injunction against my client without notice. The last issue, and I hate to end on a softer note, was the issue of the bond, because I think I heard it doesn't matter, there doesn't need to be a bond, but I'm certain this panel is aware the only recompense for a party against whom an injunction was improvidently entered is to seek recourse against the bond. In the absence of a bond, there is no recourse. So it is absolutely imperative that there be a bond, and it's absolutely imperative that the bond be put in place summarily. And in this case, there was no basis for it to be delayed. For all of those reasons, I respectfully request that the court reverse the trial court on both of the issues before you.
Thank you.
Thank you both very much. In order to leave our virtual courtroom, you should click the leave button on your Zoom screen, and then you'll be off into the ether.